So, Chapter 4 of CMADD, Functions and Duties of the Company Secretaries. First one is our subject's name only. First one is CRVI, so Corporate Insolvency and Restructuring. Second one is Corporate Compliance Management, CMADD. And next one is Strategic Management, Securities Management and Compliances, CSR, Corporate Due Diligence, Corporate Affairs, Treasury Function, Human Resource Management, Foreign Collaborations and Joint Ventures. Okay. Next, so according to section 205 of Companies Act, CS has to perform the following functions and duties: to report the board about compliance and to ensure that the company complies with the applicable secretarial standards, and to provide a guidance to the directors of the company, to facilitate in the convening of meetings and attend the board and committee meetings, general meetings, and maintain the minutes of these meetings, to obtain the approvals from the board, general meeting, government and such other authorities, to represent before various regulators, and to assist the board, to assist and advise the board in ensuring good corporate governance and complying with the corporate governance requirements and best practices, to discharge such other duties as have been specified in the under the act or rules. So majorly focus on the board related points, it is way easier. And next, as per regulation 6 sub 2 of SEBI LODR, compliance officer of the company is responsible for 4 things: ensure, coordinate, ensure, monitor. Ensure, coordinate, ensure, monitor. Ensure, coordinate, ensure, monitor. First, ensure is conformity with the regulatory provision. Coordinate with the reporting to the board. Next, ensure that the correct procedures have been followed. Monitor email address of the grievance redressal division as designated by the listed entity for the purpose of registering complaints by the investor. Next, CS as a part of senior management. Senior management means what? Senior management means officers and personnel of a listed entity who are members of the core management team excluding the board of directors, and shall also comprise all the members of the management one level below the chief executive officer, MD, whole-time director, manager, and shall specifically include the functional heads by whatever name called, and CS and CFO. So whoever includes, whoever excludes. Separately include list is core management team, comprise all the members of the management one level below the CEO, MD, whole-time director, manager, and functional heads CS and CFO. Only one thing is excluded is board of directors. This is a senior management. So CS is having the opportunities in following 2 domains, that is CS in employment and CS in practice. And some of the legal terminologies: section 2(1)(c) CS Act, company secretary means a person who is a member of ICSI, and company secretary has been defined as a secretary, or a company secretary means a company secretary as defined in 2(1)(c) of Company Secretaries Act, who is appointed by a company to perform the functions of the company secretary under Companies Act. So company secretary means who is appointed by a company to perform the functions of the company secretary under the Companies Act 2013. Section 2 of 25, company secretary in practice means company secretary who is deemed to be in practice. Why they said deemed to be in practice? Means deemed, if they enacted as they are practicing, those also included. Deemed to be in practice, it means the person who is practicing and deemed to be practicing, both are included. Next, 2 of 51, KMP. KMP in relation to company means KMP important, either of the subjects question may turn up. So read CEO or MD or manager. So CEO, MD, manager. Next, CS, whole-time director, CFO. Such other officer not more than one level below the directors who is in whole-time employment designated as KMP by board, and such other officer as may be prescribed. Next, associate member. Associate member means shall on his name being entered in the register of members be deemed to have become an associate, and as long as his name remains so entered shall be entitled to use the letter ACS after his name to indicate that he is an associate. So if in register of members his name is mentioned, he is a ACS. So what is eligibility to be entered? Means he has to pass the examination conducted by the dissolved company, because ICSI was before incorporated as a company. So has passed the examination conducted by the dissolved company and has completed the practical training. Second point, has passed the qualifying examination and completed the practical training as prescribed in the regulation. third, has passed such other examination and completed such other training outside India as outside India as is recognized by the CG or council as been equivalent to examination and training prescribed in CS Act, and has registered himself as a student with the Institute of Chartered Secretaries and Administrators, London, and had passed the final examination or professional program examination of that institute, and had either possessed or undergone the prescribed practical training. And last is an Indian citizen who is a PROA, that is person resident outside India, has become a member of Institute of Chartered Secretaries Administrators, London, after passing the qualifying examination conducted by that institute, and possessed the required practical experience in India or abroad, or undergone the prescribed practical training as stipulated. Candidates passing the final examination or professional exam. So first one is dissolved company. In that exam has been qualified and practical training completed. Second one is examination qualified and completed the training as prescribed in present regulations. Third one is outside. Fourth also outside. Fifth also outside. Third one is outside India, equivalent to CG as or council, and fourth one is London, and fifth one is also related to London but person India citizen or PROI. Next, fellow members. Fellow means a fellow member of the institute. Section 5 of CS Act 1980. So firstly, whenever a person completes the CS, he firstly entered in the associate members. To be entered in the fellow members, there is some procedures which need to be followed. So first, a person being an associate, so his name should be in an associate register of members. Next, he has to be in continuous practice for 5 years and continuous in India for 5 years, and he should possess such qualification experience, and he should has the experience acquired as a result of that 5 years continuous experience, and he has to make a payment and payment of fees and make an application to be entered his name in the register of members as a fellow. He is a fellow member. So first he should be an associate in India for a continuous period of 5 years. He should be in continuous practice, and he should have such qualification and practical experience. That experience should be acquired as a result of continuous practice of 5 years, and he can make an application to the institute by paying with the fees to be entered his name in the register of members as a fellow. He will be a fellow member. And next, eligibility to be entered his name in the register of members as a fellow is, he was a fellow including honorary fellow of the dissolved company. So again dissolved company related, and was admitted as a fellow under now earlier regulations, and is an associate and has been continuous practice in India as a CS for at least 5 years. He also can apply and get the his name in the register of members of fellow. Next, is an associate for a continuous period of not less than 5 years and possess such qualifications or practical experience as may be determined by the council. Next, no associate member shall be admitted as a following if he has been found guilty. He has been found guilty of any professional or other misconduct, and his name has been removed from the register, or he has been imposed a fine, or at any time during the preceding 5 years as on the date of the application. This will be checked for 5 years only. As on the date of application, if before preceding 5 years he has been found guilty and removed, or has been removed, he has found guilty and his name is removed from the register, or fine has been imposed. If this thing happened, he cannot be fellow, and he has not completed such minimum number of professional development credit hours as determined by the council. Next, COP. Regulation 2D of CS Regulation 1982. COP means a certificate granted under this or earlier regulation. Certificate granted under this or earlier regulation entitling the holder to practice as a CS. A member is entitled to continue as a PCS whether in India or elsewhere only after obtaining a COP. Now deemed to be in practice. Earlier in section 2 clause sub 25 we have read that company secretary in practice means a company secretary who is deemed to be in practice. So what is the deemed to be in practice? Now we will see. Section 2, clause 2 of Company Secretary Act, a member of institute shall be deemed to be in practice when individually or a partnership, means either himself or through with the partners with one or more members of the institute in practice, or in partnership with members of such other recognized professional. Recognized professional means CA and CMA. We are CS, so other professional means CA and CMA, as may be prescribed, is in consideration of the remuneration received or to be so. Remuneration is received or yet to receive, and he engages himself in the practice of profession of CS or relation to any company. First, he engages himself in the practice. Next, offered to perform or perform services in relation to promotion, forming, incorporation, amalgamation, reconstruction, reorganization, or winding up of the companies, means restructuring related stuff. Next, offers to perform or perform such services as may be performed by unauthorized representative of a company with respect to filing, registering, presenting, attesting, or verifying any documents including forms, application returns by or on behalf of the company. So, offers to perform or perform such services. First, unauthorized representative of a company. Second, as a share transfer agent, an issuer, a share and stockbroker, a secretarial auditor or consultant, an advisor to a company on management including any legal or procedural matters, issuing certificate on behalf of for the purpose of company, holds himself out to the public as a CS in practice, renders professional services or assistance with respect to matters of principle or detailing relating to the practice of profession, means renders professional service or assist the person who is rendering professional services. Next, renders such other services as in the opinion of counsel or may be rendered by a CS in practice. Next, Register of Members, Regulation 3 of CS Regulations 1982. The register shall include the following particulars about every member of the institute, namely full name, date of birth, domicile, residential and professional address, membership number and the date on which his name is entered in the register, his qualification, whether he holds a COP, email ID, mobile number, telephone number, if any, and such other particulars as may be determined by the council. The member shall communicate to the institute any changes of his details entered in register within 30 days of such change. Removal from the register of members. As per section 20 of CS Act 1980, in following cases the council may remove from the register of the names of any member of the institute. First, who is that from whom a request has been received to that effect. So, if I am a CS, I am requesting, please remove my name, then they will remove. Who has not paid any prescribed fee required to be paid by him, who is found to have been subject to disabilities mentioned in the section 8, means he attains some disability, or who for any other reason has ceased to be entitled to have his name borne in the register. So, he is no more entitled to have his name mentioned in the register, or he attained the disabilities mentioned in section 8. 4 points. Council shall remove from register of members the name of any member in respect of whom an order has been passed under the act removing him from membership of the institute. Next, disciplinary mechanism. In disciplinary mechanism, if the misconduct is related to first schedule, then board of discipline. If misconduct is related to one or two or both, then disciplinary committee will look after. Disciplinary Directorate. Section 21 provides for establishment of disciplinary director headed by the officer of the institute designated as director and such other employees for making investigation in respect of any information or complaint received by it. Where the director is of opinion that member is guilty of any professional or other misconduct mentioned in first schedule, the matter shall be placed before the board of discipline. Where the director is of the opinion that the member is guilty of any professional or other misconduct mentioned in the second or both schedules, second or both, means if it is only first schedule, board of discipline. If it is second or both, then disciplinary committee. Next, board of discipline. Board of discipline shall be constituted by council of institute under section 21A of CS Act And Board of Discipline shall follow summary disposal procedure, means fasterly solving the cases. Summary disposal procedure, where the Board of is of the opinion that member is guilty of professional misconduct mentioned in the first schedule, it shall afford to the members an opportunity, means before giving any taking any action, Board of Discipline will afford an opportunity to the member of being heard, making an order against him, and may thereafter after giving the opportunity of being heard, they will take the actions, namely reprimand the member, remove the name of the members from register up to a period of 3 months. 3 months. Impose such a fine as it may think fit, which may extend to 1 lakh. And disciplinary director, he will submit all the shall submit before the Board of Directors all the information and complaints where he is of the opinion that there is a no prima facie case, and Board of Director may, if it agrees with the opinion of the DD, close the matter, or in case disagreement, may advise the director to further investigate the matter. So DD is a helping hand for Board of Directors and disciplinary committee. Next, disciplinary committee. According to section 21B of Company Secretaries Act 1980, a disciplinary committee shall be constituted by the council. Disciplinary committee shall consist of president or vice president of the council as the presiding officer, and 2 members. So total 3 members. First is president or vice president, and 2 members to be elected from amongst the members of the council, and 2 members to be nominated by the CG from amongst the members of eminence having experience in the field of law, economics, business, finance, accountancy. So totally 5 members. One is president or vice president, who will act as a presiding officer. Next, 2 members to be elected by the council. Next, 2 members to be nominated by the central government. So 5 members of committee. Disciplinary committee consists of 5 members. If disciplinary committee is of the opinion that member is guilty of a professional or other misconduct mentioned in second schedule or both the first and second, it shall afford to member an opportunity, and after that take an action that removing the name of the members of member from the register permanently or for such period as it thinks fit. Second, reprimand the member. Third, impose such penalty as it thinks fit, which may extend to rupees 5 lakh. Next, authority of disciplinary committee, Board of Discipline and director have powers of civil code, SIIT. Appeal to authority, section 22A. So appellate authority shall be deemed to be appellate authority for the purpose of this act, subject to certain modification. Accordingly, any member of the institute aggrieved by an order of Board of Discipline or disciplinary committee imposing on him any penalties referred to 1 lakh or 5 lakh may within 90 days from the date on which order is communicated to him prefer an appeal to the authority. Even the DD, Director Discipline, may also appeal against the decision of the Board or Board of Discipline or Direct Disciplinary Committee to authority if so authorized by the Council within 90 days. So, the member against whom and the Director or Discipline both can prefer within 90 days an appeal. The authority may entertain an appeal such after the expiry of said period of 90 days if it is satisfied that there was a so after 90 days also can accept if sufficient cause is there. So in appeal, the authority may, after calling for the records, can revise any order made by the board or the Board of Discipline or disciplinary committee and may confirm, modify or set aside. Second, impose any penalty or set aside or reduce or enhance the penalty, or C, remit the case to Board of Discipline or disciplinary committee for further inquiry. Next, pass such other order as authority thinks fit, provided that the authority shall give an opportunity of being heard to the parties concerned before passing any order. And now certain provision relating to the misconduct. In this first schedule and second schedule has G points, that is for professional misconduct in relation to company secretary in practice, professional misconduct in relation to members in service, professional misconduct in relation to members of the institute generally, Other misconduct in relation to members in generally, professional misconduct in relation to company secretaries in practice, professional misconduct in relation to members of institute generally, other misconducts. In other misconducts, the following can be an illustrative example of other misconducts. Where a company secretary retains records, books of accounts and documents of the client and fails to return to the client on request without a reasonable cause, where a CS makes a material misrepresentation. First one is he fails to return the books or documents, records to the client. Second one, CS makes a material misrepresentation. Third, where a CS uses the services of his apprentice for purpose other than the professional practice. So apprentice work can be used for professional practice only, but he is using for other than professional practice. So it is other misconduct. Next, conviction by a competent court of law. Fifth, wrong publicity causing damage to the client. Wrong publicity, where in the opinion of a council, members bring disrepute to the profession or institute as a result of his action, whether or not related to the profession. Member is held guilty by any civil or criminal court, punishable with imprisonment for a term not exceeding 6 months. Furnishing false declaration to institute. Next, non-compliance with guidelines issued by the council of institute. Now comes professional misconduct in relation to CS in practice, part 1 of first schedule. Part 1, first schedule, clause 1. PCS should work by himself but can allow other person to practice in behalf only if he is a company secretary in practice or as in a partnership or employed with him. If he not working himself or allowed to the person other than the mentioned, he is deemed to be guilty. Next, CA and CMA can be a partner of CS. Yes, it is allowed. So to prove there are two persons as a partner, 4 conditions. First, sharing of profits or losses, taking decision together, sharing the responsibilities of such decision making, acting on behalf of each other and binding other person with one own acts of the commission or omission. Means in simple, he should work himself or he can work along with a company secretary in practice or as a partnership or as employed. Either these two options. If other than this, he will be deemed to be guilty. And any amount transaction between the CA, CS and CMA running as a mega firms is okay. But other than the CA, CS, CMA acting for the work related to CS, other than any amount is regarded as misconduct. And to be a mega firm, the persons also should be eligible. CA, CS, CMA, 3 of them, they can form a mega firms and they can exchange the transactions and take the payments. But other than this, if other than CS, if other than any outside the scope of the institute, the persons who are not eligible to receive amount, if they are doing and they are receiving the amount, it is a misconduct. This is a clause 2. Next, clause 3. And third clause is CS should not take money from any other person. But if CS takes money from the mega firm consists of CA, CS and CMA, then it's okay. Mega firm or partnership firm. If he is taking money from mega firm or partnership firm of the eligible CA, CMA and CS, it's okay. But any other than this, it is misconduct. And the person who was qualified also given in the above list. It is CA and CMA and Bar Council of Advocates, Indian Institute of Architect and Institute of Actuaries, and membership of the professional bodies institute whose qualifications related to company secretaryship are recognized by the council. So first one is CA, CS, CMA, Bar Council means advocate related, and architects, actuaries. These are all okay. With them can share the profits or money, whatever. Next, partnership with CS and other professional bodies is allowed. Other than other professional bodies like commission agents, like this, partnership is not allowed. So partnership has to do with qualified persons. CS can do partnership with professional bodies like CA, CMA, and other than that, not allowed. If did, it is a misconduct in clause 4. And clause 5, PCS seeking the work. If he gets services to perform from source which is open for PCS, it is not a misconduct. The sources is now we have finished in clause 2 and clause 3 and clause 4. From these sources means from CA, CS and CMA and his clients, if he get work from these people, it is not a misconduct. But any other than this clause 2, 3, 4 and his clients, if he gets work from other source, it is a misconduct in clause 5. And clause 6, PCS can ask to work from one CA, if A, CS and B, CS. B can ask from A can ask from B, that is allowed. And if any client has asked for tender and the CS has replied for the tender, through that tender or through the work he performed, any new work has been came, that is also okay. This is clause 6. In clause 6 there are list of activities. Like he is asking for the work, these are all not allowed activities. From point 1 to 16 points are there, these are all not allowed, and in that some exceptions are there that are allowed. And next would not fall, next allowed list from 1 to 15, that is allowed list, means he can seek the work from them. In circular or advertising in the newspaper, means advertisement in the newspaper is not allowed, and circulating a circular letter offering the work he performs, or expeditiously means he will work compared to other CS in the compared to other CS, I will work more faster. Expeditiously, he cannot be superior compared to other CS, he should not show that. And highlighting any provisions or any changes in the laws to existing clients, okay, but other than existing clients he cannot say the relevant changes. If he shares any amendments or any changes with other than the clients, it is misconduct, means he is seeking for the work. Next, issuing the handbills. Next, publication in the telephone directory. In telephone directory, two things are there. Normal advertisement in telephone directory works, but showing supremacy is misconduct. And next, 7th point is I will charge less fees. That is also not allowed, it is a misconduct. And he cannot say I am a specialist in branch of law, that is also misconduct. And in prospectus, when mentioning the details of the CS, should mention CS of our so and so company, but specialist in the CS, no. If supremacy shown, it is misconduct. And for clients asking for further references, means that is also misconduct. He cannot request the present client to get more clients, that is misconduct. Next, 11th point, frequently is press announcements has been made that I am not available for the professional work, that he cannot do. And in public interviews, highlighting the professional attainments, means he did that he did the all attainments, what and all professional attainments he did, that he cannot highlight in the public interviews. But sending a biodata to an organizer, means there may be any event conducting, if he sends the biodata, that is okay. And writing to institution that I am available to the work, he cannot solicit that. Even for third person also he cannot approach, I am available to work, please give me some work, he cannot ask. And for any trade association, his ready availability for rendering professional services, that also he cannot say. And 15th, sending his profile to person, companies, firms without any request, means if they request, means a client or any company is requesting to send the profile, it's okay. Without they asking or they requesting, if CS sends his profile, that is misconduct. And including names of other professional in his profile circulated to various persons. Next, allowed list, means these are allowed, okay. Publishing in the journal of the institute or newspaper any change in the professional address, means if address changed, that okay, that they can mention. Next, second point, in journals, in classified columns there will be a separate column. In that column he is asking for recruitment of staff, I want staff, any people are there, that requirements he can put, but he cannot ask for work, he cannot solicit for the work. And next, third point, constitution of the firm, if any changes in the firm, he can publish information, but limited to bare facts only, specific facts only, bare facts. If more information added, it may lead to misconduct. And if any new year, like new year by CSX so and so, like that we can in the invitation card or in any greeting, happy new year by X a CS, like that, okay. And appearance as a speaker in a private capacity is okay. Without connection, he should appear as a speaker or any on stage in private capacity as a speaker, okay. And participation in professional capacity in the TV with a where reasonable amount of biographical matter may be given, means introduction. The person who is appearing in the TV, they will give their introduction, but they cannot say I'm specialist in any so and so branch of work. That is not allowed. Supremacy is not allowed, simple rule. And editing or publishing any professional journal, newspaper or magazine allowed, and writing the articles allowed, and associating with intention to help the society just as a charity or to help the society works, but to solicit the clients, not, it is a misconduct. And writing to his existing clients about the changes or amendments if any allowed. And clients ask before which company worked for, then he can provide the details of the work. He voluntarily, without client being asking, if he provides, that is a misconduct. He should not disclose the work of company he performed earlier. And any assignments handled can be added in his profile, but he should say like I did merger, that's all. He cannot say I did merger of X and Y company, only he has to disclose the work, not company's name. Issuing advertisement in the chartered secretary for opening a branch or seeking partnership, means inviting a PCS to come along to work, this is allowed. And issuing any advertisement within the framework, and securing professional work. And next 14th, securing professional work from another PCS, okay. And responding to tenders is also okay. Clause 7, advertisement plus CS designation as per guidelines, okay, but other than the guidelines, not allowed, it is a misconduct. And in designation X a CS and BCom, this is allowed, but cannot write X a CS and lawyer or advocate, like that he cannot write. The university degree is allowed, CS and BCom is allowed. Clause 8, and if company offers any work to the PCS, he should communicate to earlier PCS, means communication to previous auditor. If he not communicated, like that only if he accepted the work, it is a misconduct. And the reply which he received from the previous auditor, that also should be retained with him. And there are two situations in which communication required and communication not required. Communication not required is certifying e-forms for various, just certifying the e-forms, right, for that communication to previous auditor not required. And giving due diligence certificate for consortium borrowers, and holding assignments as retainer for a company or group of companies, issuing search reports, issuing certificates as a contemplated under SEBI LODR 2015, giving legal opinion. For all this, communication is not required. And communication is required when signing or certifying the annual returns. Annual return, this is a big thing. Issuance of secretarial audit report in terms of section 204 of Companies Act. Issuance of certificate of securities transfers, certificate of reconciliation of capitals, conduct of internal audit of operations of DP, certification of corporate governance under SEBI LODR. Next, clause 9, performance based fee is allowed, any excess is not allowed, it is a misconduct. Clause 10, if he engages in any business or occupation other than the profession of CS, if permitted by council, okay. If it is not permitted by the council, it is misconduct. Again, he can act as a director, CS can be a director. So, council has decided not to issue certificate of practice to members engaged in other professionals such as CA, CS, CMA and advocates, and also the CS who is in employment, for them also certificate of practice will not be issued. So that company secretary in whole time practice comes into actual. So, whole time practice he should be in company secretary only. Both cannot handle. So, company secretary whole time practice, for them all will be given. But if along with CS he is doing CA, CMA and lawyer and advocate, for them certificate of practice will not be given. And even for employment also certificate of practice will not be given. So, if a member as holding certificate of practice and engages himself in employment, he will be held guilty. And if a person hold both CA and CS and working both practicing as a both CA and CS, it is also misconduct. What all activities council has permitted is authoring the books and articles, holding of life insurance agency license for the limited purpose of getting renewal commission, holding of public elective office such as MP, MLA, MLC and others, honorary office bearership of charitable, educational or other non-commercial organizations, acting as a justice of peace, special executive magistrate and the like, teaching assignments. So long as the hours during which a member in the practice is so engaged in teaching do not exceed average of 3 hours in a day, irrespective of the manner in which his such assignment is described or remuneration is well. Means if he is into teaching, only 3 hours a day is allowed. More than 3 hours means he cannot hold the certificate of practice. Means if more than 3 hours he teaches, it is not permissible according to the council. If it is not permissible, means it is a misconduct. Holding of COP while teaching more than 3 hours a day is a misconduct. And permission to be granted specifically with ICSI council in if substantial interest is there, and MD or whole-time director of a body corporate, when he is deemed to have substantial conflict of interest, is 25% of more voting power at any time during the previous year or owned beneficially by such member. In case of any other concern, if such member is entitled to, at any time during the previous year, to not less than 25% of the profits of, means if in profit or in voting power 25% of more if holds, then he is said to have substantial interest, and the person who holds substantial interest cannot act as a CS for the company for auditing. And clause 11, a specific work should be performed by the CS but assigned to some other non-CS. He is not eligible to do such act, but a CS in practice is assigned for that person. So the person who assigned is done the misconduct. Here comes the first part end. Now we are moving to part 2 of first schedule. First schedule, first part was related to certificate of practice. Now it is employment in CS. And in this first clause, a work has been assigned to CS in employment. He not performed that work, rather he offered some other person who is not eligible to do that work, and he offered some money. That is not allowed. Sharing of his remuneration is not allowed with the person who is not eligible to do work. So he has to do by himself. And next clause 2 is he is guilty of professional misconduct if, being an employee, accepts or agrees to accept any part of the fee, profit, gain from a lawyer, CS or broker engaged by such company, firm, person or agent or customer by firm by way of commissioner. Means other than the remuneration, he cannot accept anything, profits, fees, gains, anything he cannot accept. That is clause 2. Next, part 3 of first schedule. Institute generally, means for both PCS and CS in employment, for both part 3 of first schedule will apply. In this clause 1, a CS is not a fellow but acts as a fellow of the institute. He is guilty under part 3 of first schedule. And clause 2 is, while giving the name in the register of members of fellow, council will prescribe some rules. So if a person whose name is entered in the fellow register of members not followed that rules, that is also misconduct, and his name will be removed from the register of members of fellow. And clause 3, while inviting professional work from another CS or any responding, or in his work, if he gives any information knowing it to be false, is a misconduct under part 3 of first schedule. If unknowingly he gave the wrong information, then he may not be held liable in the for part 3 of first schedule, provided he should prove that he was not known. Next, part 4 of first schedule. This is also general limits for both PCS and CS in employment. Clause 1 of part 4. So, if a member in practice or in employment is held guilty by civil or criminal court for an offence which is punishable with imprisonment for a term not exceeding 6 months. So, less than 6 months if is a punishable either civil or criminal court, then for clause 1 part 4 he is not eligible. He is done other misconducts in general. And clause 2, a member of the institute, whether in practice or not, if he disrepute to the profession or the institute, whether or not related to professional work, means he disrepute the institute. That is clause 2 part 4. And there is a list of the misconduct which is a misconduct under clause 2 of part 4 of first schedule, like sending an email to number of members, that is like not respecting the ICSI decision, non-parliamentary, not respecting any filthy language, arranging dharna means against, and instigating students or other members by raising issues pertaining to syllabus, training, examination or any other, means for students saying that this syllabus is not good, like that they cannot raise the issues. And misusing the confidential data available with the office of the institute for personal purpose. Misusing the confidential data. Inviting government offices for chapters or regional councils by spending heavily on their travel and stay to get a personal mileage, means to get personal advantage, heavily spending on them. Tampering with the books of accounts minutes. Next, part 1 of second schedule, where the matters are to be dealt with the disciplinary committee constituted by the council. Clause 1 for PCS, means in practice. If a PCS in practice shares client info to others without his permission, that is misconduct, as it breaks the trust and confidence of the client. Clause 2. If PCS certifies after examining, it is okay. But if he certifies any document, record, anything without examining, that is misconduct in part 1 of second schedule. And clause 3, any contingent future transaction is there, in that his views or opinions cannot give, he should not give. Future is always uncertain and there is always an element of contingency. PCS cannot become a fortune teller, means he cannot become Baba, he cannot say that. He should clearly insert appropriate disclaimer clause if he is giving an opinion which is contingent transaction. Clause 4, a CS in practice is having substantial interest, but also he expressed his opinion, that is also misconduct. And clause 5, some fact came to know to the CS, but he not disclosed, which should be disclosed, means the fact which should be disclosed, he not disclosed, so that is also misconduct. The fact which should be disclosed, if not disclosed, that is misconduct. Next, clause 6, there is a material misstatement. PCS not reported that in his report, that is also misconduct. Clause 7, PCS should work due diligently, but he is not working, and with gross negligence he is conducting his duty, that is also misconduct. And in case Nemi Chand versus Commissioner, it was held that gross negligence import high degree of careless conduct. Next, clause 8, a PCS gave opinion without knowing complete information, that is also misconduct. Like he has to obtain the sufficient information before forming of the opinion, but he did not obtain the sufficient information. Before obtaining the sufficient information, he gave his opinion, that is clause 8, that is also misconduct. Next, clause 9. Next, he performed any work without focusing on secretarial practice, the procedures which led down to form that opinion, that he is not followed. Without following any procedures, randomly he gave the opinion or did his work. Clause 10. If a client gave any amount apart from the fee, means normal is a fee, apart from his fee, any other amount, if client gave, the purpose for which client has given, for that purpose only CS should use. And until that purpose arise, he should keep that amount aside. If he uses for any other, it is a misconduct. But if money received from the client is related to traveling and conveyance, for that he can use, means for traveling and conveyance only he got the money, so for that he can use, no need of keeping aside and for purpose, that all not matter. Traveling and conveyance, for that if client gave, for that purpose he can use. Next, clause 1 of part 2 of second schedule. This applies for both, means part 2 of second schedule applies for both PCS and CS in employment. Clause 1. If CS does any act in violation of the guidelines issued by the council. What are the guidelines issued by council so far is 9 points are there. Display of the particulars on website, approving firm name, compulsory attendance, dress code, issuing complaint certificate, maintenance of register of attestation services, issue of advertisement by the PCS, change of name of a concern or firm, guidance for use of own logo by PCS. Next, clause 2 of part 2 of second schedule. And being in employment, he discloses confidential information which he acquired during the course of the employment without taking the permission by the employer, that is misconduct. But he disclosed information as it was required by law, it is not a misconduct. And if permission has been taken by the employer, that is also not misconduct. He can disclose in two situations. First, it is required by the law and permission is obtained from the employer, then he can disclose the confidential information. Without this, if he discloses, it is a misconduct. Next, if he includes any information, statement, written form submitted to institute, council or a committee, director, discipline, board of director, disciplinary committee or QR, quality review board or appellate authority, knowing them to be false, means he know that the information is which he is giving to mentioned authorities at somewhat, for them he is giving the information which is he know that is a false information, so that is a misconduct in clause 3. And clause 4, misuse of money. If he embezzles money received in his professional capacity, misusing of money, clause 4, that is also misconduct. And part 3 of second schedule, this civil or criminal imprisonment for term exceeding 6 months. This part will not get attracted at very first instance of being guilty, but it is attracted only after the final appeal, as it may be disposed, means until he have the chance to appeal, until that this part 3 will not get attracted. After he applied for appeal and appeal got disposed, or after the time lapsed to file an appeal lapsed, only then this part 3 will attract. And next, there is a procedure in inquiry before disciplinary committee and procedure in hearing before this council. And next, multidisciplinary firm. A member in a practice may form multidisciplinary firm with the member of other professional bodies. Other professional means, if I am a CS, so I can, other professional bodies means C and CMA, as prescribed under 168A and 168B of the Company Secretary's Regulation 1982, in accordance with the regulating guidelines of the Council for Functioning and Regulation of such disciplinary firm. Next, UDIN, Unique Document Identification Number, is a unique number for identification of documents attested by CS in practice, shall be generated at time of signing the certificate report, which shall be mandatorily be mentioned in the certificate or report along with the certificate of number. UDIN shall be generated at the time of signing of reports, written certificates and other documents, or can be generated 7 days in advance of the date of such signing of the as above. Before signing, 7 days in advance also can generate UDIN. So what is UDIN? UDIN is a 17-digit system generated number which is used to verify the authenticity of a documents attested or certified by a CS in practice. Quoting UDIN on certifications with respect to professional services has been made mandatory from 1st October 2019. And UDIN guidelines have been issued by the ICSA in order to enable the stakeholders to verify the authenticity of various documents, prevent counterfeiting of various attestations, provide ease of maintaining register of attestation and certification, ensure compliance of guidelines issued by institute with respect to sealing on the number of various certifications. Means in chapter 15 we will read how many certification or signing can PCS do, that limit. Ensure compliance of guidelines with respect to sealing or number of various certification or attestation services. Auto prefill details of certification or attestation services rendering by practicing members in off form renewal of certificate of practice. Next, ICSI guidelines for advertisement by company secretaries. The following activities are permitted for a company secretary in practice as means to advise. First, display the scope of work, create a visual identity in compliance with the, means he can create a visual identity but it should be in compliance with the guidelines. Next, display of the location and decor of the workplace, display of firm name, logo or any other identity or on uniform, professional updates and write-ups appearing on local radio or television, giving speeches or lectures at any platform including seminar, conference, training programs, holding professional seminars, sponsoring any event, helping with community programs or doing voluntary work as a professional for charitable organization. Use of social media like FB, Insta, LinkedIn, Twitter, YouTube, WeChat, Telegram and WhatsApp or and other media of similar nature. Next, advertisement restrictions. Means this cannot do in the advertisement. What? Not be in violation of provisions of act, not be false or misleading, not claim superiority over any or other company secretary. Supremacy cannot show that. Fourth, not be indecent, sensational or otherwise of such nature which may bring disrepute to the profession. Next, fabricated or false testimonials, no, cannot refer himself as a specialist or experts and not represent that the quality of professional service is greater than the quality of others, not constitute a guarantee or warranty, and in no way indicate the charging of a fees contingent on outcome, like that should not indicate, and not contain any reference to past success or results, and should not pleasing the customers, and not contain any humorous slogans. Come to us, we will tell you how that slogans should not be. Professional liability of a company secretaries may be divided into two categories, statutory and contractual. Statutory means statutory liability of a company secretary refer to those that the company secretary is legally bound to obey. The following are the sum of the statutory liability of company secretary. First, maintenance of all the records and documents of the company, arranging the statutory meetings of the company, issuing share certificate, dividend warrants and bonus share certificates to shareholders, preparation of minutes of various meetings and maintaining minutes book. Contractual liabilities. The company secretary has also to take care of his or her contractual liabilities. The company secretary has to enter into a service contract with the company or client. Therefore, the company secretary has some liabilities arising out of his service contract. Below mentioned are some of the contractual liabilities of the company secretary. Liable for breaching or exceeding his authority, liable for disclosing secret information, liable to fraud, liable to abide by the terms and conditions of service contract, protect the interest of the company. What is the disciplinary mechanism in case of misconduct of clause 5 of part 1 of first schedule of company secretary? So, if anything related to first schedule will be handled by board of discipline. So, board of discipline provision we have to write. That is section 21A Company Secretaries Act 1980. Reprimand the member, remove the name from the register up to 3 years and up to 1 lakh fine. And if member is not satisfied, he may prefer an appeal within 90 days to the authority, and the authority may confirm, modify or set aside and impose any penalty or set aside, remit the case to board of discipline for further inquiry and pass such other as authority thinks fit. This is the first answer. Second, write a short note on board of discipline, fellow member, appellate authority. Board of discipline, just now we have discussed, that is section 21A Company Secretary Act, reprimand, remove 3 months, impose fine 1 lakh, And if a member is not satisfied, he can prefer an appeal to authority. And even if disciplinary director himself can also prefer an appeal against the order of a member on behalf of member. Even disciplinary directorate can also prefer within 90 days. And authority may grant an further even after the expiry of 90 days if sufficient cause is there. And they can confirm the order or modify or investigate for further investigation, pass such order as authority thinks fit, and impose any penalty or set aside or reduce or enhance the penalty. Next, fellow members. So fellow member section 5, that we is an associate for 5 years continuously holding, and qualifications and practical experience is there. um, on payment of fee on application can enter his name in the register of members of fellow. And there is a list, eligibility list. And there is 2 points in which, that is, if he get guilty and if he not completed the professional development credit hours, he cannot be entered in his name in the register of members of fellow. Next, appellate authority, as per section 22A, um, if any person aggrieved, if any member agreed by the decision of board of directors or disciplinary committee, may prefer an appeal within 90 days from the order communicated. And even director discipline also can prefer an appeal to the board against the decision of board of discipline or disciplinary committee within 90 days. And authority may confirm, modify, set aside, or impose penalty or enhance, reduce, or third, remit the case back to board of directors or board of discipline or disciplinary committee, and pass any other order as it authority thinks fit. But before doing this all, opportunity will be given to the member. So what third question, what are the consequences of non-compliance of ICCI guidelines for advertisement by company secretary 2020? Any non-compliance or violation of these guidelines, as may be enforced from time to time in any manner whatsoever, shall be deemed to be professional misconduct, and the concerned member shall be liable to the disciplinary action under the Company Secretary Act. That is Schedule 1 and Schedule 2. Reprimand, remove 3 months, permanent remove, fine 1 lakh, and one more is 5 lakh. That point we have to write. Schedule 1 and Schedule 2. Mr. Y is appointed as a company secretary in ABC Public Limited. Mr. X, MD of the company, would like to know from Mr. Y him about the duties and functions of company secretary as per statutory norms. Prepare pointers to describe the duties and functions of CS in order to brief Mr. X. So for this, first we have to write company secretary in practice meaning, and then we can write functions and duties points. And fifth question, this is not a valid arrangement, and in practice is mandatory. So this is first schedule, first clause. So penalty action will be taken by the board of directors. That is reprimand, remove for 3 months, fine 1 lakh. That points only, board of directors points. Next, sixth, a complaint of a professional misconduct is filed with ICSA against Ravi, a PCS. Disciplinary committee of ICSA is of the opinion that Ravi is guilty of professional misconduct mentioned in second schedule to the Companies Act. The committee, after affording Ravi an opportunity, ordered for removal of his name from the register permanently, and also imposed penalty of 10 lakh. Is the action of committee valid? What actions can the board of discipline, a separate authority, take if it is of the opinion that the member is guilty of the professional misconduct mentioned in the first schedule to the Act 1980. In this first point is even if the case is related to second schedule, they can impose up to 5 lakhs. So 10 lakhs is wrong. And we have to write separate 2 points, first schedule and second schedule. In first schedule, board of directors, board of disciplinary will handle, and the second disciplinary committee will handle. These are the points they can do, these are the points they can do. And in any case, 10 lakhs is not valid. 5 lakhs is the maximum limit, even if it is related to second schedule. And if it is first schedule, maximum is 1 lakh. Rama, a PCS, posted a request on WhatsApp group of PCS for providing secretarial audit in any company. She also made a similar request on WhatsApp to her college friends. Has she committed professional misconduct? First one is okay, means in his WhatsApp, posted a request on WhatsApp group. Posted a request is not valid, but Why not valid means soliciting the customer is misconduct. Clause 6 of part 1 of first schedule, pleasing the customer. So first schedule will come. So board of directors, that 3 points, reprimand, remove, and fine up to 1 lakh. Has she committed professional misconduct? Yes, under the first schedule of clause 6. Chapters 4